Today marks 1 year since Jayland Walker, a 25-year-old black man, was killed by Akron police officers after a traffic stop. 8 officers fired 94 shots at Walker, and he sustained 46 gunshot wounds. Walker was not armed when he was gunned down. In April, an Ohio grand jury declined to bring charges against the officers, saying they were legally justified in their use of force. Which is why today, at a Justice for Jayland rally, the Walker family and supporters took their demands directly to the steps of the Department of Justice in Washington. Here's what one family attorney had to say.
We have filed a lawsuit against the city of Akron for $45 million for each bullet that struck Jayland. That's right. We have called on the Department of Justice, and we stand with this community as we hope that the Department of Justice will continue their conversations with us and get involved.
Joining me now is Paul Butler, MSNBC legal analyst and a former federal prosecutor. So, Paul, how, in theory, could the Department of Justice get involved? Could this case, in theory, become federal?
Not only in theory, but it's got to, Joy. The Justice Department can do a pattern and practice investigation of the Akron Police Department, just like it's doing in Minneapolis, where the police killed George Floyd, and in Louisville, where the police killed Breonna Taylor, and in Baltimore, where Freddie Gray got his spine crushed while he was in police custody. The data shows that when DOJ and federal courts are looking at police departments, they do better, including killing and beating up fewer people.
So let's talk about this lawsuit. So, when people hear $45 million lawsuit, they go, OK, well, the family will at least be able to exact some sort of justice, even though it doesn't bring their loved one back. But I don't think people understand that if they win, it is the taxpayers of Ohio who will pay that $45 million, not the police department. It won't come out of the police pension. It doesn't harm the police departments at all. How do we work in a system where it's the taxpayers and the insurance taken out and not the police department at all who pay these settlements?
And so people have heard about qualified immunity. That's this doctrine created by the conservative Supreme Court that says, you can't sue me, I'm a cop. What that does is protect officers from personal liability. But Joy, we know that's what works. If it's coming out of your paycheck, it makes you want to treat citizens better, to treat all citizens with respect if you know that there could be consequences to you. And again, we're not seeing officers held criminally responsible. This is a routine but tragic failure of the law to hold bad apple cops accountable.
Let's go to the Owens case, the A.J. Owens case. So the state attorney issued this explanation for why they charged manslaughter and not second-degree murder, which is what the family wanted. In order to prove the crime of second-degree murder, the state must prove the existence of depraved mind toward the victim at the time of the killing. Depraved mind requires evidence of hatred, spite, or ill will or ill intent toward the victim at the time of the killing. As deplorable as the defendant's actions were in the case, there is insufficient evidence to prove this specific and required element of second-degree murder. But hang on a second. Witnesses said, and she admitted, the shooter admitted she called the woman's children, A.J. Owens' children, the N-word and other racial epithets. She admitted screaming racial epithets. Make it make sense how this is not second-degree murder. She shot through a closed door with a 9-year-old standing on the other side. She didn't even get charged for reckless endangerment.
It's second-degree murder. So, Joy, first, it took the local sheriff almost a week to arrest the killer as they tried to see if she had a defense based on Florida's notorious stand your ground law, which she does not. And now the prosecutor is showing the same kind of undue deference by undercharging this defendant. Manslaughter simply does not fit the gravity of this offense. Second-degree murder requires proof of what the law calls a depraved mind. That means a reckless killing with ill will. Well, Joy, what could be more reckless than shooting a mother through a closed door in front of her children? Where could you find more ill will than this defendant who admits that she called children in the neighborhood the N-word? She admitted that on another occasion, she threw roller skates at these little kids and told them to go fetch them In Florida, you get to be a racist and you get to use the N-word, but what you don't get to use is to use that mindset as an excuse to kill an innocent black person. This defendant should have been prosecuted for murder.
And the prosecutor claimed that when she threw the skates, it was in the same incident. That was why that's why A.J. Owens went to that door, because she literally threw an iPad and roller skates at her children, and were little kids. I don't know what more depraved mind you could have than trying to assault little kids and then shooting their mom with a 9-year-old next to them. I don't understand what this prosecutor's done. We're going to try to hopefully we'd love to get that prosecutor to come on. We would love to talk with you, sir, because we'd love to get you to explain what you've done here. Paul Butler, my friend, thank you.